So E&O policy does not cover claims relating to breaches of contract. So for example, if a producer breaches a contract provision with a writer, that won't be covered by E&O insurance. But there is a narrow exception to this rule, and that's in implied in fact agreements. Those will be covered by E&O, and so a producer must assess whether or not there were any implied contracts that were established through conduct. A lot of times people mistake or they think that a submission of an idea is sufficient to constitute or to establish an implied in fact contract, and that's not correct. The court has stated that there's two really clear requirements for establishing implied in fact contracts, and that is, first, the person who is sharing the idea must express the expectation to be compensated prior to sharing the idea and if they share the idea. And secondly, the recipient, so for example the producer, must know that there's this expectation of compensation and then voluntarily accepts the receipt of the idea. And so in general, in terms of limiting your potential liability in like an implied in fact agreement, it's possible if a producer ensures that every person that comes before them to submit any sort of idea signs an idea release submission form.